Some of your questions will be answered and new ones will be raised. We'll now start our slide presentation. So our meeting goals and objectives are to understand how the legalization of marijuana in New Jersey results in a need to change the way companies deal with the hiring process and with the performance and safety of employees in their workplace. Our speakers today will focus on the impacts of legalization on the drug testing process, especially when used in hiring and for workplace safety, the changing environment of employer and employee rights, and the new approach to evaluation and management of the possibly impaired worker. At the end of today's session, we will leave time for some questions and answers. During the program, feel free to send in your questions through the chat feature on your screen. It's now my pleasure to introduce today's speakers, Dr. Randy Klein from The Doctor Is In, and Frank Steinberg of Steinberg Law. Dr. Randy Klein is the medical director of The Doctor Is In, a blended primary care, urgent care, and occupational medical practice with offices in Clinton, Flemington, and Phillipsburg. The Doctor Is In has been serving the Somerset, Hunterdon, and Warren County communities for 35 years. Dr. Klein is also a certified medical review officer and has been evaluating and verifying the legal results of drug tests for 25 years. Frank Steinberg of Steinberg Law has been counseling companies and executives in business and employment matters for more than 30 years. Centrally located in Somerville, New Jersey, Steinberg Law provides small and medium-sized businesses and professional practices with a quality of representation comparable to much larger businesses. And he represents clients throughout New Jersey. I'll now turn over our program to Dr. Klein.
Good afternoon, everybody. We'll get our first technical move here as I'm going to share off my screen. So just bear with me. Okay. So today, my part of the program, I will be talking about drug and bat testing, the process. I'll be talking specifically about marijuana testing in light of the New Jersey law and the two problems related to marijuana testing. And I will be talking about the three most common drug testing scenarios that many of us are involved in already, and the impacts of the new legislation legalizing the recreational use of marijuana in New Jersey. Okay. So drug and bat testing, the process. I think it's worthwhile for everybody to understand because you do send staff members here to our offices or to other places and you get back results. But in between, there is a process that needs to go on in order for the process to work and for it to be legally done in a legal way. So you want, of course, a center with trained and certified staff to do this type of collection and testing. You want equipment that meets industry standards and is calibrated on a regular basis. And of course, we want special facilities to avoid the potential for tampering of the specimens. Moving along, when the patient or your employee arrives, we want to make sure that the patient is checked and instructed on the process, that their pockets are emptied, that we have water shut off in the bathroom, again, to avoid tampering. We put bluing in the water, so again, that's another way of avoiding any tampering. And final and important, we want to make sure that there's a chain of custody process where every step of the way, the sample is witnessed and signed off on in terms of its move through the process before it leaves to go to the lab. As far as the certified MRO, There's a lot of training involved in evaluating the results of those specimens. Many of you, when you've gotten results back that are negative, we know negatives are negative, but not all non-negatives are positive. That's a confusing statement. But when we first get back a result that shows that there's some substance in the sample, we can't immediately assume that that result is positive just because there are substances in that sample. So for instance, there are allowable limits for some substances that will still enable I as an MRO or another MRO to report the results still as negative for the purposes of testing. There may be presence of an alternate substance that explains why the drug test is showing a result that is allowable. There are also legal prescriptions that may show up in a sample, and as long as they are legal and written in the name of that individual, the patient, the results still may be reported as a negative. All of those results all of those processes, I should say, that we need to go through contribute to some reporting delays that you sometimes see on non-negatives. So when you get a negative back same day or next day, that's kind of easy. When you see that your results are not coming in right away, it may not always be just a problem over at the lab or a delay in the testing process in the office, but it may be that we need to reach out to the individual and get more information from their physician, prescribing physician, just to determine whether the findings we're seeing need to be reported to you as a positive drug test or as a negative drug test that has some explanation for the reason for the findings that we're getting. So that may explain some of the delays. And of course, good communication is always key. So if you're not getting a result and you call us, we may explain what's going on with the delay, or we may reach out to the lab to find out what's going on, but making sure that you have good communications and good reporting with the facility that you're using to either do the collections, or in my case, when I'm the MRO, with the person who's doing the interpretation, make sure you have that good dialogue going. Failure to perform testing and or evaluation appropriately can lead to legal challenges of the results or even lawsuits directed at the company. So it's important that we do all this right. And if there's a little bit of delay that's explainable, again, work with us, make sure that we're getting results that are right and that are legally defensible. Okay, so marijuana testing. The two problems that come up for us with marijuana testing that make this a difficult situation now with the legalization in New Jersey are as follows. First of all, the federal government and some other states still consider any use of marijuana to be illegal. So we have a disconnect between the state laws and the federal laws. What this means is that sometimes you're going to have employees who have to meet the higher standard of the federal law, and you still need to do marijuana testing and understand the results. That includes the Department of Transportation very commonly, truck drivers, train engineers, ship pilots. That includes, excuse me, federal installations, nuclear facilities, certainly anybody who's working for military, and anybody who's a federal government worker. And then finally, for some more local companies, if you have a federal contract, you have people who are working on a project that falls under federal guidelines, you still may need to follow federal guidelines, and despite the state rules, still do marijuana testing and perform the drug-free workplace as defined by the federal rules. And so even in New Jersey, any worker under 21, marijuana would still be considered illegal. And so we have a little bit of a quandary there, whether to test differently for your employees who are under 21 versus over 21. The other issue is that unlike, say, the BAT breath alcohol test for alcohol, which measures the current level of recently ingested alcohol with a known scientific curve of metabolism, the test for marijuana really only measures metabolites of marijuana use any time that occurred within the last 30 days. So there is no correlation between the finding of marijuana in the drug test and a determination of current or present use or the current condition or behavior of an employee. Creates a huge problem when it comes to determination of whether or not somebody's behavior or safety issues are related to a current use of marijuana, as opposed to, as we were talking about before, a current use of alcohol. So this is the second big problem. The three most common drug testing scenarios that we are all involved in are the pre-employment, the random testing, and the post-incident. Now, on the pre-employment, unless the employee falls under the federal testing jurisdiction, in the state of New Jersey, the continued inclusion of marijuana in drug testing needs to be reconsidered. This is because under the laws, as Frank will talk about later, the determination about hiring and firing or administrative issues relating to an employee you cannot use the results of a marijuana test to act on hiring and firing practices. So we just want to know, I've heard that from some of our employees. Well, we're keeping it in our testing because we just want to know. And it puts you in a tough spot, because if you just want to know and then the employee believes that you've acted on a hiring or firing decision or administrative decisions based on the result, you could be at risk for legal action. So that's why we've got Frank on the other part of this call. Random testing. These tests are usually used to promote workplace safety or quote unquote a drug-free workplace. And again, other than when following federal guidelines, the testing for random testing, I should say, that continues to include marijuana, this needs to be reconsidered. Again, we are trying to promote drug-free workplace and workplace safety, but if somebody is using marijuana 2 weeks ago and they're still going to test positive today, what is the use of the result of that test in terms of the workplace and workplace safety? And then finally, we have the post-incident. So this is where we have something happen at work that's a safety issue, and many companies or contracts with unions have in it the responsibility of getting drug testing done in association with the treatment of the individual or anybody who may be injured. And the purpose of this test generally has been to aid in determination of impairment in the workplace, and to help to decide how to deal with the employee, as well as how to address the potential legal responsibilities for these workplace incidents. Again, because there's a disconnect between the results of a marijuana test and the determination of impairment, the inclusion of marijuana testing here may not be able to be used in ways that you were used to doing it in the past. So, as I mentioned, because the current test for marijuana has no relationship to the measurement of current impairment, a positive test can't be used for this purpose. And our attorney is going to address this and some of the other difficulties that are presented to you in this most recent law further as part of our discussion today. So that's the end of my focus on the drug testing piece of the legislation and its impact on you at your companies. I'm going to be turning things over to Frank Steinberg in just a moment, so that he can go into more depth about the legal challenges that it presents. We will leave time, as we mentioned at the end, for questions and answers, but please don't hesitate to be sending in your questions now so we can kind of get a list of them and address them right at the end of the program. I thank you for your time, and I'm going to turn things now over to Frank. Let me just see if I can end my sharing, and we'll turn it over to Frank.
Okay, good afternoon, everyone. I'm really happy to be here, so I can enlighten you a little bit about this brand new law of ours regarding recreational marijuana. Thanks to Randy and Ronnie and the whole crew at the Doctor Is In for giving me the opportunity to participate in this today. So I have somewhat lightheartedly, but that's just the way I am, called this recreational marijuana wafts into New Jersey. But the title kind of fits because, you know, when smoke wafts in, it just sort of goes all over the place, right? And that's sort of the situation we are in here. We're not quite sure where the whole recreational marijuana law is going to take us legally, but we're going to find out together. So let's get started. And let me ask you to go to the next slide. For some reason, I can't control it from my computer, so I'll just rely on somebody remotely here. But here's what we're going to discuss today. The first thing is the potential impact on employers and employees of CREAMMA, CREAMMA, that is the modestly entitled New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act. It's brand new. It was only signed into law by Governor Murphy in late February. And it is long. When I say it's a 240-page law, it is. It's that, and that's without the implementing regulations yet. So in a lot of ways, we're dealing today with a relatively small portion of the law, but it's going to be fleshed out eventually by regulations that are going to be established by the Cannabis Regulatory Commission. And that hasn't happened yet. And my best guess is it's not going to happen probably until, late August, early September at the very earliest. But until we have that kind of guidance, we're just making educated guesses right now. But we have a good basis to make some of those guesses. So let's go through those. And then also I will try to highlight as best I can some of the legal risks that employers face in dealing with legal recreational marijuana, and some ways you can try to get ahead of the process a little bit and see if there's a way to minimize problems by doing some advanced planning. Next slide, please. Thank you. The one thing we won't discuss today, because it's the second prong of legal marijuana in New Jersey, and that's the J. Koenig medical marijuana law. There's some interlap or overlap between the two, but that's for another day. Next slide, please. All right. So what does CREAMMA actually do? What it does is it legalizes the recreational use of marijuana for persons over the age of 21. As I mentioned before, there are regulations to follow that are going to fill in some of the gaps in the statute, but we don't really know for sure when that's going to happen. The good news for those of you who are running businesses or running HR departments is that the employer obligations that arise under CREAMMA are not active until regulations are adopted. So there's a little bit of time to get in front of this thing if you're so inclined. And my suggestion as an attorney would be so inclined. And then just the last complicating factor for the moment is, as Randy mentioned, cannabis is still illegal under federal law. We'll touch on that a little bit as to what the effect of that's going to be legally. Next slide, please. Okay, here's the big takeaway. All right, from all of those 240 pages to the extent that they employ to businesses, you can't, number one, refuse to hire somebody solely because they are recreational marijuana users. Similarly, if you've already hired them, you can't fire them or take adverse employment action against them solely because they use recreational marijuana. So the solely is a big word, and we're going to come back to it a couple of times as we continue our discussion here. The good news from a perspective of employers is that it is still legal, completely legal under the statute, to maintain a drug-free workplace. Now, there are some, I've called them exceptions, but they're probably more complications. But you are still allowed to maintain a drug-free workplace and insist that your employees not be subject to any kind of intoxication while they're working. Next slide, please. All right, this is where we get into the boring lawyer stuff, but you need to know. The term adverse employment action, if you recall from the previous slide, you're not allowed to take adverse employment action against someone solely because they use cannabis. And this statute is a little unusual because it actually defines for us what they mean by adverse employment action. In other contexts, it's a little more amorphous. But in this context, it would be refusing to hire, it would be barring from employment, and your guess is as good as mine as to exactly what that means. I've got some guesses, but I don't think they're important for purposes of our discussion today. You can't fire someone, all right, that's an adverse employment action. You can't force someone into a retirement, in quotes, but the quotes are mine, not the statutes. So, none of the, the old trick of saying, we'll allow you to retire so you don't have a termination on your record. I think that's what they're referring to there. And you can't discriminate against them in terms of compensation, number one. So you've got to pay them the same, or in any term, condition, or privilege of employment. And so bottom line is recreational users of cannabis by law now have to be treated exactly the same as any other employee. Next slide, please. Okay, more boring lawyer stuff. Okay, this is my effort to synopsize a 248-page law in one slide. All right, we've already gone over the name. I'm not going to try to do that again. If you or your attorneys want to know where to find it, it's at New Jersey Statutes Annotated 24:6I-31. That's where it starts. Then you just keep going from there. Like a lot of statutes, CREAMMA starts with a series of legislative findings. That is what legislatures do so that the courts, when it comes time to interpret the law, have some idea of what the legislature was trying to accomplish. There are 15 such findings in the case of CREAMMA. They address all sorts of things, but not one of them is its impact on business. So the business community has largely been left out to dry on this thing and to deal with it as best we can. So that's the legislature is not giving us any guidance there. The law delegates rulemaking to the Cannabis Regulatory Commission, as I mentioned before, and again, maybe later this summer or in the fall, I would guess. For our purposes today, the really important stuff starts at section 24:6I-50 of the statute, and that's the part labeled consumer protections. And what that means for our purposes is employee rights. And next slide, please. All right, so I couldn't do it in one slide, so I had to go to at least two. All right, so it says, with respect to employers, employment actions, etc., individuals can't be denied any privilege or right, including but not limited to, and it goes on through a series of things that you can't do. But the important general takeaway is that you can't act against them just because they're using cannabis products. The second section down there is that in terms of testing, the presence of cannabinoid metabolites in bodily fluids can't form the basis of a refusal to employ or otherwise penalize that person. But then we get into an exception here, and that's again what Randy was referring to earlier, unless that would put the employer in a position of violating a federal contract or causing it to lose federal funding. We'll do that in a little more detail in a second. Next slide, please. Okay, so this is the third, and I promise you it won't get any worse than this. All right, so section 53, this is an important one. No employer shall refuse to hire or employ a person or shall discharge him from employment, et cetera, because he does or does not, for that matter, smoke or vape or aerosolize or whatever. And the employee shall not be subject to any adverse action by an employer solely, there's that word again, due to the presence of the metabolites in the employee's bodily fluid. So, again, that simply brings us back to what we said at the very beginning. You've got to be really careful, because the fact that people use cannabis products is not going to be something that you can deal with easily, and it's going to cause you to have to be very careful about how you handle employees who test positive. Let's go to the next slide, please. All right, so the practical impact of this is that, without saying so, the New Jersey legislature has made recreational marijuana users a protected class. And that's a term you'll be familiar with if you're in HR, but it encompasses many, many things. There's 20 some of them in New Jersey, but they're things like age and race and disability and that sort of thing. Exactly how much the cannabis users are going to get in the way of legal protection, like in the case of, say, age or race discrimination, is still not well defined, and we're going to have to see how that shakes out. Next slide, please. All right, New Jersey is not the only state with recreational marijuana law. These statutes are not all the same. New Jersey's goes, pretty far, probably as far as just about any, in terms of giving the employee rights. So some states, for instance, will have exceptions to the ability to use recreational marijuana for employees in safety-sensitive jobs. It's not the case. Not the case in New Jersey. Okay, CREAMMA just applies full force to everybody. Next slide, please. All right, so we talked a second ago about the carve-out for conflicts with federal law. So some of the things that are going to come into play there, and again, Randy covered some of this, but for employees who are in safety-sensitive positions, that is to say, employees of federal contractors who are in safety-sensitive positions, failure of a drug test alone may support an adverse employment action in that kind of situation. An example of that would be, and again, Randy mentioned this, truck driving regulations promulgated by the United States Department of Transportation. Another area involves recipients of federal grant funds, and the portion of this that I'm familiar with relates to airports that obtain federal airport improvement grants. So they get money from the federal government to help pave runways and that sort of thing. But every sponsor of a project, every airport, if they take federal money, they have to sign what's basically a contract called a grant assurance, and it's 23, 25 paragraphs long, something like that. But one of the things they have to commit to as a condition of getting the money is to abide by the Federal Drug-Free Workplace Act. And when they say drug-free, that under federal law includes cannabis products. So New Jersey has carved that out of CREAMMA. And if there's a sort of an overriding federal law, then that's what governs. But again, this is going to get complicated, and I think you need to review your policies with your attorneys and make sure that you're dealing with all this appropriately, especially if you do have federal work, whether by contract or by grant or otherwise. Okay, and so that would get us where we need to go on that. Yep, next one, thank you. Okay, so here's from the employer's perspective. This is what I think of as good news. You can still maintain and require a drug-free and an alcohol-free, for that matter, workplace. The passage of CREAMMA does not take away your ability to do that. Whether you choose to do it is a different issue, but you can still have policies and procedures and employee handbooks that can be loaded up with information telling your employees what the rules of the road are for the use or non-use of cannabis products while they're on the premises, in the workplace, or during working hours. Okay, and you can take adverse employment action against an employee for cannabis use if those two criteria or one of those two criteria are met. That is to say that it takes place either in the workplace or during work hours. Next slide, please. Okay, so you can still do pre-employment screening. You can still test, and this is all, by the way, sort of expressly provided for in CREAMMA. You can test for reasonable suspicion of use while engaged in work. You can test if there are observable signs of cannabis intoxication. Those last two are difficult, and Randy sort of touched on that because of the nature of what the cannabis testing tests for. And it's not particularly useful in terms of, is somebody using marijuana right now, or even like narrow it down much below the 30-day limit that Randy was discussing. You can also screen for employees for use during work hours, but with the caveat that you have to screen everybody. You can't just single out, the people you think are using. You can do random testing for employees in safety-sensitive positions, although I'm not sure how that squares with the general treatment of safety-sensitive positions under the statute, but maybe the regulations will answer that question for us. And again, after there's a work-related accident, and it doesn't matter whether you suspect cannabis intoxication to be involved in that. Once there's an accident, somebody drives a forklift off of a platform or something, you can test for cannabis, and you can do that without any difficulty. Next slide, please. All right, so having done some testing, what do you do with the results? And the short answer is you can use the test results to determine appropriate employment action or to use in deciding what kind of discipline should be imposed upon an employee, but always bearing in mind that failing a test for cannabis metabolites is not going to be enough by itself to take action against the employee. There's going to have to be something else. Next slide, please. All right, so when can businesses take action? That is not addressed by the statute at all. Again, the regulations, whenever they're enacted, may help to clarify this, but the educated guess is that anytime you have a good faith belief that an employee either has used or marijuana in the workplace or is under the influence while working, then you'll be protected, and you can take some kind of disciplinary action against the employee. But next slide and we'll talk about how. Right. So how do you form a good faith belief that an employee is using? Now, this is not well defined. The easy one is direct observation of use. All right. So, employee Trudy comes in and says, you know what, I just saw employee Tom sitting in his car at the lunch break out in the parking lot, and he was smoking what appeared to me to be a marijuana cigarette. All right, so that's probably enough to give you the ability to investigate further into whether there's some violation of your regulations going on, and if so, whether you can take action. Maybe there's a pattern of suspicious behavior. Somebody's, disappearing from work for a little while and, coming back a half hour later, behaving differently. Again, I don't know. These are all essentially guesses, but I can see that as being a reasonable basis. I don't need to talk about the real-time test or lack of thereof, because Randy covered that. But now we come to the conundrum. All right, what guidance has the legislature in its wisdom decided to give us about how we can figure out whether we have enough of a good faith belief to terminate an employee or discipline an employee for some involvement with cannabis during work hours. And they have come up with the idea that we should hire experts. Let's go to the next slide, please. We've already talked about most of this stuff, but let's go one more slide if we could. Okay, so experts. All right, so the word of the day in this area is WIRE, W-I-R-E. Stands for Workplace Impairment Recognition Expert. And this is, as I've noted here, a mythical creature that does not yet exist in New Jersey. Nonetheless, the legislature has told us that we have the ability to use them to try to determine whether employees are impaired in the workplace or during work hours. And the fact of the matter is, you need to know the word, because at some point you're probably going to have to hire one. The Cannabis Regulatory Commission is going to set the standards of who's qualified to be a WIRE expert, what training is needed, what tests are going to be allowed. All of these are questions that remain to be answered. The interesting thing about it is that I just saw this a day or two ago. The New Jersey State Police are involved in a program of what they call drug recognition experts, DREs, and this is sort of a 12-step process by which appropriately trained state police officers can sit down with a person who's suspected of unlawful drug use and evaluate whether, in the officer's opinion, that person is impaired by the use of some intoxicant. The problem, of course, is there is a significant legal challenge to that right now on the theory that the state police program is scientifically invalid. And they can do all 12 of their steps if they want, or so the argument goes, but nothing that they conclude has any scientific legitimacy. Now, I don't know where that stands in terms of the court challenge, but there's real scientific evidence to back that up. So who gets to have significant impact or input rather into the training and evaluation of usage in the training of WIRE experts? by the state police, of course. So again, we're just going to have to see how this all works out. But just the last little point on wire experts is you can either employ them yourself, get somebody trained up and employ them yourself, or I'm sure there's going to be a little cottage industry of wire experts who are going to develop as a result of this law. And you can go out and hire one of those, but you're going to probably need one. There are a lot of questions involved in this. I'll try to keep this short because I don't want to cut too much into your time to ask questions if you want to. But we don't know what the effect of a wire expert's opinion is. Whether it's binding on the employer or not, just don't know. We don't know whether you need to have that opinion in hand before you take action against an employee, or whether you can wait until later. Next slide, please. Just one other little source of additional confusion, if we need any more in this area. If you happen to be a multi-state employer, you have offices in New Jersey, maybe you have an office or two in Pennsylvania or New York or Delaware. Their laws are different than ours, and you may well have to apply different standards in terms of cannabis usage from one state to the next. So again, just don't leave this one to chance. Make sure that you get some competent advice on this, and and don't try to use the Pennsylvania rules for the New Jersey employees, because it's going to land you in trouble, or at least it could. Next slide, please. All right, so what are you going to do? How do you deal with all this? And again, here are some more guesses, but they're educated guesses. All right. The prime directive of human resource work: document, 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 and do it compulsively in this case, please. Remember that what you're going to have to be able to do is establish that if you take some kind of adverse action against an employee, you're going to have to be able to establish that it was not solely because of the use of marijuana. So if there are performance problems or cultural fit problems, or whatever the issue may be, make sure that you have a really good written record of that. And it's a pain in the neck, I know, but it'll save you a lot of grief potentially down the road. Second thing is review your current policies and make sure that they're consistent with the new law for whenever that new law becomes effective. But as I say, we have like a couple-month window here in all likelihood to pull this stuff together. Train up your HR people, train up your managers, make sure that everybody understands what the standards are. And I say walk the high wire, just you're going to need to hire a wire expert at some point. So at least look into that, or talk to your attorneys or somebody who can make recommendations for you. Next slide. Okay, everybody always wants to know what the liability risk is, and that in this case is the $64,000 question. We remember we talked earlier about other kinds of protected classes, and those are classes that are subject to employment discrimination. And they can all sue you if they want to under the New Jersey law against discrimination. In this particular case, even though what the legislature has effectively done is created a protected class of recreational marijuana users, the statute does not create a right to sue, what we call a private right of action. That could have been intentional. It could have been, they could have just been punting and figuring they're going to let the courts decide what to do about this. But it's very much an open question, and we need to at least be aware of the possibility that if you fire somebody for marijuana use, then you possibly could get sued, but we don't really know. But there are other statutes. There are anti-retaliation statutes like our whistleblower statute, Conscientious Employee Protection Act. You might be subject to suit under that. You might be subject to suit for violation of public policy as expressed in CREAMMA. I don't know. We're just going to have to see how a lot of this stuff shakes out. And again, some of it may be defined a little better by the regulations when they finally get enacted. Next slide, please. If there is a next slide. Okay, I guess that. All right, I guess I actually have reached the end of my presentation then. So thank you all very much for listening. And if I can, if you're interested in getting a copy of the slide deck, just contact me.
Thank you very much, Frank. We do have one or two questions. The first one is for Dr. Klein. If an employee has a medical marijuana card, will they pass a DOT physical?
Okay, so medical marijuana card is a state-issued card. The DOT guidelines fall under federal guidelines. So right now, since the federal guidelines trump state guidelines in this matter, there is no acceptable finding for the use of marijuana and marijuana products in somebody who needs to get certified for a DOT driver. And so that's a no. You cannot be a certified DOT driver and be using marijuana under any in any form or under any program. There is a move at the federal level to try to legalize marijuana at the federal level. That's, again, for a whole other discussion, and I'm sure will involve a lot more regarding safety-sensitive issues and whether there will be carve-outs for those people out on the road driving trucks over a certain size, people working at nuclear facilities, military workers. I suspect this is going to be even more complicated than, as Frank mentioned, our 240-page state law. And I think it will take a while to get that all sorted out. Right now, can't use marijuana if you're a DOT driver. If you have a driver, I apologize, Ronnie, but if you have a driver in your company who is not under DOT guidelines, you're now talking about a safety-sensitive situation, yes, but it falls under New Jersey rules. And so if it's not a vehicle that requires a federal DOT certification, then that person is permitted to use marijuana, obviously not to be impaired while they're driving, but recreationally when they're not driving.
And there's one other question also for you, Dr. Klein. How big of an issue is recreational cannabis likely to be for the average business? What % of tests return positive results?
Okay, so currently we see probably about 10% of tests coming back overall that we do here in the practice showing positivity for marijuana. Again, in the state of New Jersey, we would no longer consider that a positive test. Companies still may be interested in the results. We have reached out to our labs so that we can, for those companies who are currently using us to do testing, we now can provide the same tests that you're doing now, or the same combination of tests that you're doing now, pulling out the marijuana result. So you can make a decision if you still want the results included, understanding you need to be careful what you do with those results. Or you can decide, we don't want to know, we don't even want to see it. And you could do the same exact drug testing that you're doing now, just having us pull the marijuana out. And again, just reach out to us at any point that's convenient. We can talk about those options. And Ronnie, you had asked me, another part of the question, the percent positive, and I
Just
thought there was another piece.
No, just how big of an issue this
Oh,
will
how
be
big
for
an
the
issue?
average-
So I think the biggest issue, you know, perhaps it's not an issue if you're, you know, running a deli, but I'm sure it's going to be a big issue for those companies that have much more safety sensitive positions. So some of your factory settings, factory companies that are running machinery or maybe have people running around in forklifts. I think companies that have drivers that are out there doing deliveries, I think it's going to become a confusing and complicated issue for you if they don't fall under DOT guidelines. So I think primarily, you know, your factories and plants and your places where people are getting behind the wheel, or they're dealing with equipment that has a lot of safety sensitivity to it, because you can't have people under the influence of anything and getting hurt or hurting other people. And that's more likely to happen in those environments.
Okay, are there any other questions?
There was, I believe, we got another question over here. First of all, somebody wanted to know about they got on late and they want to know about the availability. As Frank mentioned about the slide deck, we actually are recording the program. So if you reach out to us afterwards, we can make either any part or the whole program available to you. We're more than happy to do that. And you hang on one moment. Oh, there was a question about cannabis use and impairment. So cannabis stays in the system from the perspective of our current ability to do drug testing for up to 30 days. Its impact, though, in terms of impairment is not directly related to the level in the system. I always get people asking me, well, if this person's level is X and this person is X minus 10, the level in the system may not at all be related to how much or how often or how recent the person used cannabis, because people do metabolize it far differently, as opposed to, say, alcohol, where everybody's metabolism rate is fairly consistent. So you can't necessarily tell by the level on the test how recently they used, how much or how often they use. How often a person may stay impaired is also very variable. Again, we know with alcohol, they talk about a drink an hour being an amount that somebody can metabolize through and no longer be impaired, say, an hour later. With cannabis, it does depend. We have people who use cannabis either for medical or recreational purposes on a daily basis and seem to be almost not impaired at all. And we have somebody else who may use it and for most of the rest of the day, not be functioning in their normal capacity. So again, this is where, as Frank was talking about, we get into this whole industry of determining impairment. We can't currently use the test for impairment until they come up with a test that can do that. We're going to end up relying on people who are trained to determine level of impairment, and that gets complicated, it gets expensive, it gets it's just going to be a very difficult process to figure out. And that's why they're still working on some of the regulations and some of the trainings. And this is going to be a process of evolution. What you don't want to be is that company that's on the front edge of testing the laws and what happens in terms of not following the rules. So that's part of the reason that we did this program for you. I'm going to put up in a moment our contact information, because I know Frank wants to be available to those people who have interests on the legal end. Certainly for me on the drug testing end, we'll make the information from the program and our contact information available as well. We have one more question. I'm leaning over to read. Hold on. Okay. So this has to do with an entity that has in its employ pilots. And they were asking about whether the FAA has any rules and regulations. So again, the F stands for federal. Federal marijuana is still illegal. So at this point, pilots, and it doesn't matter whether you're a commercial pilot, piloting small planes, all people who are piloting any aircraft fall under FAA guidelines. FAA is federal right now. If you're under federal guidelines, you cannot be using any kind of cannabis products or test positive, and you are required to be tested for marijuana. Any test for marijuana that's positive negates your ability to perform that function. Any other, we're good with questions as far as that goes. So as I said, I'm going to put up contact information. We obviously, I think we have it up in front of you now. Obviously, we're interested not only in providing anything we can to support you in this particular project, but one of our reasons for coming out to you on this was to share the concept with you that if this program is helpful and this way of getting information out to you is helpful, we're certainly happy to put together other programs that may be of other common interest in the future. So I want to thank everybody who got on for spending the hour with us. I want to thank Frank for his time and expertise as well. And again, feel free to reach out to us after the program with anything else.
Thank you all. Bye-bye.